Hello everyone, welcome to our channel Ivy Legal. In continuation to Evidence Act lecture series, in this video we are going to discuss about section 100 and 128 of Indian Evidence Act. So, in our previous videos we have discussed about section 126 which dealt with professional communications. So that section was very important with respect to Evidence Act because that section entitled to keep the communication between advocate and client as confidential. But moving ahead with further sections, this section 128, 129, these should be read in continuity with section 126. So let's look at what 28 talks about. 128 states that privilege is not waived by volunteering evidence. So if a party basically making the communication under section 126 with an advocate, vakil or barrister or pleader gives evidence at his own instance of matter covered by communication, that does not amount to waiver of privilege. This basically means that while giving communication, while disclosing communication with advocate, if the client at his own instance also produces some evidences, that does not shows that client is voluntarily waiving his privilege to keep the matter confidential. And the exception for this is that if such party, if a client questions the lawyer on the very matter of communication, that will amount to consent of waiver of privilege. So as long as client is not questioning the lawyer on the communication, on the matter of communication, there is no question of waiver of privilege. You can't say that client, since client has also at his own instance produced some evidences to corroborate his communication, this shows that client has now waived off his privilege. The only case in which client can waive off his privilege is either by way of his express consent or when he questions the lawyer on the same matter of communication. Then in that case the lawyer can disclose the communication, because lawyer has been questioned on the same matter, so he can disclose the communication so as to bring clarity on the same before the court. Coming on to section 129. Now we'll discuss about section 129. This section states that confidential communication with legal advisors. So in this section basically states that the bar of section 129, the bar of section 126 is partially lifted by section 129, which states that also apart from in cases of section 126, there is certain confidential communication which is to be kept. So that confidentiality is being lifted under section 129, wherein it states that no one shall be compelled to disclose to court any confidential communication taken place between him and his legal advisors. So this is basically what section 126 also stated, that if any communication taking place between legal advisor and the client, that should not be disclosed. But when a client offers himself as a witness, he may be compelled to disclose such communication, as court require in order to explain any evidence which he has given but no others. So basically, when a client offers himself as a witness, he may be compelled to disclose such communication, as a court require in order to explain any evidences which he has given but no others. This section clearly states that if client is offering himself as a witness, then the court is entitled, or court can compel the client to disclose all such communications in order to explain any evidence. So that was all about section 129. मिलेंगे अगली वीडियो में जहाँ बात करेंगे कुछ और सेक्शंस के बारे में. टिल द टाइम, बाय बाय, टेक केयर.